Hi, Alecia Hall, Florida estate planning probate attorney and realtor. In this video, I'm going to show you how one sentence in a poorly drafted will could have resulted in a loss of $265,000 to my client. First time visiting my channel, welcome. Please don't forget to like, comment, and subscribe so that you can be notified as soon as I upload new content about estate planning, probate, and Florida real estate. There are plenty of options out there for do-it-yourself or DIY estate planning. And it can be tempting. It can be very tempting for someone to spend, say, $100 to download a will and fill in the blanks because they think they're protecting their family. But in all actuality, unless you actually understand the law behind those provisions and also understand what those provisions mean, you could be making very expensive mistakes by saving money downloading your documents. If you do decide to retain an attorney to handle drafting of your estate planning documents, it is very important that you vet that attorney. Ask them questions. How long have you been practicing in this area? Is this an area that you regularly practice in, or is it something that you kind of do on the side to supplement your other practice areas? The reason why that's very important is because I do come across very often, I actually have two this year alone in 2022, where attorneys who are not estate planning attorneys have drafted wills, and I look at them and my eyes bulge because I can't believe what I'm looking at. The language that I'm going to be showing you today was actually pulled from a will that was drafted by an attorney. I looked her up because I couldn't believe what I saw, and it turns out that she does not practice estate planning, which is exactly why she did what she did. It's very important to, one, not do it yourself, but also don't work with an attorney who is not an estate planning attorney. So if they practice 50 million other things, or if you go on their website and they are really, really strong with their criminal representation or divorce, they're a divorced attorney and they're very strong as a divorced attorney, I wouldn't necessarily go to them for estate planning services because they are probably highly specialized in that other area of law and they can miss things that they aren't aware of in the estate planning realm. So examples that I'm showing you today are actually from two different cases. The one with the improperly drafted will, and then another case where a massive claim was filed. So basically, what I'm going to show you is how things could be completely different if my facts from two separate cases were to sort of meld and become one case. First, let's talk about the Florida homestead. In Florida, your homestead, so your actual home where you reside, is protected from most creditors. It's not protected from a mortgage lender, or let's say you have a construction contract for repair or improvements to the home, and also it's not protected from taxes and assessments. So what that means is the homestead is protected from a forced sale in order to pay creditors other than the ones that I mentioned before. Here's the amazing thing. In Florida, that protection is unlimited. So whether your home is valued at $200,000 or $200 million when you pass away, it is protected from a forced sale. Also, when you pass away, that protection extends to your surviving spouse or related heirs. That's it. In order to extend the protection, the property has to be passed to the surviving spouse or related heirs. What happens if the property is transferred to anyone other than a related heir or surviving spouse? The protection is completely gone. In other words, all creditors are entitled to look to that asset for repayment. Now, let's jump into the actual will with the poorly drafted language. As you can see in this will, Section B, titled Homestead Property, states, I direct that my homestead property be sold by my personal representative and the proceeds from the sale be distributed into equal shares, 50-50 between my son and daughter. The sentence directs that the home is sold. It does not state that the home is going to be transferred to my son and daughter. That is the problem. First of all, if this sentence was drafted properly, the personal representative would not even have the right or ability to sell the homestead because the homestead is technically not an estate asset. It is exempt from the estate. Secondly, the will directs that the personal representative sells the property. Guess what didn't happen? The property is not being transferred directly to the son and daughter. We now have a problem. This property, because of this one sentence, has now completely lost its homestead protection. Now take a look at this Medicaid claim that was filed in a completely different case of mine. As you can see by the red highlighting, Medicaid has filed a claim in the amount of $265,061.17. If that claim were filed in the case with the improperly drafted will, the home, which is only valued at about $209,000, would have to be sold in order to pay Medicaid. Now, Medicaid would only receive whatever that home sells for, up to the max, up to the amount of its claim. But see the difference? Because of that one sentence, instead of that home being transferred to the children free and clear of this Medicaid claim, we now have a situation where the home has to be sold to pay off a claim, and based on the value of the home, that leaves nothing left for the children, nothing for them to inherit, all because of one sentence in an improperly drafted will. By the way, if that will were drafted properly and that Medicaid claim was filed in the case, what I would do is I would actually reach out to Medicaid and ask them to consent to my discharge in light of the fact that the only asset is the homestead. And Medicaid would take a look at the file, they would look at the inventory, they would take a look at the will, or if there is no will, they would confirm that there is no will, and they would see how I'm distributing the assets. And they would actually provide me with a consent to discharge so long as the people inheriting that home are related heirs or the surviving spouse. The consent to discharge would have special language in it that specifically indicates that if assets are found, non-exempt assets, in that instance, the Medicaid claim would need to be paid out. And their turnaround time is very quick. I mean, I get these in 48, 72 hours from them. They're really responsive. It's just a matter of making sure that you have all the documents that they need ready to go. I can email it to them and they review it internally, and then they email me that consent, which I would then file with the court. So at the end of the day, while we all try to be mindful of saving money and finding ways to save money, estate planning is just not one of those areas where you want to either do it yourself or go with a discount attorney who does not practice estate planning regularly. And FYI, don't worry about my clients. In the case with the $265,000 Medicaid claim, thankfully, we are not dealing with a poorly drafted will. In fact, we're not dealing with a will at all. So that property is being transferred by the laws of intestate succession. Click on the link above if you want to learn a little bit more about what happens if you die without a will here in Florida. Also, in the other case with the poorly drafted will, we actually haven't filed the case yet. I'm still putting together all the documents to get ready to file that petition. Thankfully, although we were dealing with a 96-year-old woman, she did not need any sort of Medicaid assistance to pay for her needs towards the end of her life. So she was not in a facility. But this could have ended really badly because it is not unheard of for someone in their 90s to need to go into a facility and for there not to be cash available in order to pay for her care. In that instance, obviously the family would have to go to Medicaid or some other government assistance. And although during her life no payments would have had to be made because her only asset was her homestead, as soon as we ended up filing that probate with the will and pursuant to the terms of the will, that home would have to be sold because that homestead protection would have been lost as a result of that will. If you live in Florida and would like to speak with a licensed estate planning attorney about your specific and unique situation, please click on the link below to schedule your free estate planning consultation. Also, if you have recently lost a loved one who was either a resident in the state of Florida or died owning property that was solely in their name here in the state of Florida, and you need assistance with the probate, again, click on the link below to schedule a free estate planning consultation. Please don't forget to like, comment, and subscribe to my channel.